It's my distinct pleasure today to introduce our keynote speaker, Judge Michael Nash, recently retired presiding judge of the Los Angeles County Juvenile Court, the nation's largest juvenile court. He is with us today to speak to the changes that took place and the challenges he met during his 25 years on the bench, working with children and families in the child welfare system. Please welcome Judge Nash.
I've been very fortunate to have spent 25 of my 40 years in public service in working in our juvenile courts in both the child welfare and juvenile justice systems. I spent my first 15 years in public service in the criminal justice system as a prosecutor and a judge. And even though I have always suffered from what I like to refer to as a crusader mentality, I was very fortunate ultimately to land in the juvenile courts in 1990, where I found that I could take advantage of that so-called mentality. Now, to understand that, one has to understand the role of a juvenile court judge within that context, and everything that I'll at least attempt to talk about tonight really flows from understanding what the role of a juvenile court judge is. It's actually a very unique role, and in fact, in California, our standards of judicial administration have a section called the unique role of the juvenile court judge. And that unique role was best described or defined by a good friend of mine and also a mentor of mine, retired Judge Len Edwards from San Jose, California, who some of you may have heard of. And what he said was this: judges in the juvenile court are charged with keeping children safe, mentoring families, finding permanency for children, and holding youth, families, and service providers accountable. Every day, hundreds of judges make thousands of decisions regarding children in crisis. We decide whether a child should be removed from parental care, whether a child has committed a delinquent act, whether a child should be committed to the state for correction, whether parental rights should be terminated, and similar issues. When parenting fails, when informal community responses are inadequate, our juvenile courts provide the state's official intervention in the most serious cases involving children and families. We are the equivalent to the emergency room in the medical profession. We have to intervene in crises and figure out the best response on a case-by-case basis. In addition, we have to get off the bench and work in the community. We have to convene child and family serving agencies, schools, and the community around the problems facing our most vulnerable and troubled children. We have to ask these agencies and the communities to work together to support our efforts so that the orders we make on the bench can be fulfilled. We have to be the champions of collaboration. So you see, the unique role of a juvenile court judge goes beyond the traditional role of a judge, which essentially is to act as a referee in the court process, or to call balls and strikes, as we sometimes say, and also to make factual and legal determinations where. Now, this role, the role of a juvenile court judge, encompasses leadership, administration, collaboration, advocacy, and engagement. We need to not only know the law, but also have an understanding of child development. What services are necessary to deal with the issues people in our courts face? What resources are available in given communities? And what are the best practices to effectively manage the process and the different roles that we play? Now, during my tenure in the juvenile court, there have been many changes and developments, many of which the court was involved with through this role, through this notion of collaboration I mentioned. And in the limited time I have here, let me just talk about a few of them. When I started in the dependency court in 1990, there were well over 50,000 children under our court's jurisdiction due to abuse or neglect. When I became presiding judge in 1997, I began keeping track on a monthly basis, and at that point, the number was over 53,000. Today, there are about 30,000. And a lot of people say, well, what's the reason for the decline? Well, there are probably a number of reasons, including the subsiding of the crack cocaine epidemic of the 1980s and 90s, which really drove our caseloads through the roof at that time. I think there's been some better social work, which kind of ebbs and flows over time. And through collaboration, we developed our adoption project, which includes a program that many of you have heard about, our Adoption Saturday program, which we started in 1998 and has become a national program. And because of that program, we've seen the completion of some 35,000 adoptions from foster care since 1998, and certainly that has helped reduce our caseloads quite a bit. Yet when you think about it, that decrease sounds good to some, but I can tell you I am not satisfied. In April 2010, we had fewer than 24,000 children under our court's jurisdiction, the lowest number that certainly during the time that I was in the court that we had seen, and probably the only time the court had ever seen a number that low was when the numbers were at some point on the way up. 5 years later, here we are in April 2014, we have 30,000 plus children under our court's jurisdiction. And there's a number of reasons for that. There are increasing numbers of youth who are over the age of 18 who are staying in the system because primarily the Fostering Connections legislation that was passed in 2008 by Congress and which has seen various iterations here in California. Those numbers are rising, and in part, and in my opinion, because at the same time that we are focusing on, or have been focusing on, these young people who are aging out of the system to really negative outcomes, we have not seen a simultaneous redoubling of our efforts to create permanency for children in the system so that they do not stay in the system longer before they age out. During the same time frame, we have seen our local agency, DCFS, filing new cases at near record levels. And that may or may not be a good thing. But the thing is, I think all of us who work in the system need to ask why. We seem to accept the fact that, oh, we're in Los Angeles, and Los Angeles is a very big jurisdiction, and therefore we're going to have a lot of cases. Well, that's fine and dandy. But we also need to ask, why do we have so many cases here in Los Angeles? Is our city worse than other places in the United States? We need to ask if the agency is maximizing its efforts to serve families in their community rather than filing cases in the court that could be serviced better in the communities. We need to ask today if there has been a philosophical shift in social work regarding family maintenance. We need to ask what part, if any, politics and a climate of fear in the agency has played in this increase. There may be good answers to all these questions, but those questions need to be asked. They need to be asked by all of us, and we need to demand that there be a good answer to all of that. Because quite frankly, at the rate, speaking from the court's perspective, we've seen so many cases in the last few years that the court is literally drowning in cases. And when you talk about courts having minutes a day to spend hearing these cases, that does not create a climate for the best outcome for the children and families that we're trying to serve in our system. Now, during my time on the court, we also did, I think, some pretty good work. And here in Los Angeles, we developed some of the most comprehensive protocols regarding the use of psychotropic medications with our children. I'm proud of that. Yet, if each and every one of us who is involved in this process does not participate in a meaningful way, by that I mean if we don't treat each of these children who we're getting requests to medicate, if we don't treat each and every one of those children like our own children, then I can guarantee you that there will still be too many children receiving medication, too many children receiving too many medications, often for the wrong reasons, and ultimately without sufficient oversight. You know, I recently testified in front of our legislature on this issue related to psychotropic meds, and everybody's looking for magic solutions about how we can improve the process. What I said was, the bottom line is you can come up with any number of solutions about how to improve the process. But once again, we have to look at the process, so we have to look at what we're doing one child at a time. In our system, we work under the notion that we're dealing with one child at a time. Every child, every family that comes before us is unique in their own way, and that really is what the juvenile court is all about. That's why it was created in 1899, to recognize that children are different, children are unique, and every one of them needs to craft their own solution. And I don't know how many of you have children. I don't know how many of you have children who have taken medication, specifically psychotropic medication. But think about the process that you went through. Think about the questions that you asked your doctor. Think about how you understand and you know the nuances of your child's behavior. Think about how, when you gave your child that medication, that you watched your child like a hawk because you wanted to see in what way, if any, that medication was helping or hurting your child or doing nothing at all. And unless everybody in the system joins their efforts or combines their efforts to attempt to do that, we can create all the protocols that we want, and it's not going to make any difference. Now, during my time in the juvenile court, we also developed protocols to increase the communication and coordination between our juvenile justice and our child welfare systems. And the good news is, I think that over the years, those protocols have reduced the number of children who come from the child welfare system, our dependency kids, who have ultimately become formal wards of the delinquency court. Yet, as I sit in court now, and people say, well, what are you doing in retirement? Well, I'm actually sitting now as a delinquency court judge. And I'm actually, it's a great opportunity for me to see if any of this stuff that we did over the years can actually work. And I've only been doing it now, I retired in January, and I've actually went back to work in March. So it's too soon for me to make any definitive statements. But I do believe that from what I've seen thus far, that if a lot of the stuff that we created is implemented in the way that we intended it to be, it can work. When it comes to these protocols that create communication and coordination between the delinquency court and the dependency court, between DCFS and the probation department, while the good news is we've reduced the number of kids who I think have crossed over, yet it's very clear there are still some real difficulties in getting the two systems to work together. and I question whether or not they really know how to work together, and at times, truthfully, I really question the desire of the agencies to do so. So there's still a lot more to do here. Now, over the years, a good thing is that there has been a decrease in the number of children and youth in group homes. This is a good trend. It's a good trend because, as I'm sure most of you know and understand, group homes are considered to be the least preferred placement for children, and for good reason. Children don't need and shouldn't be growing up in congregate care. Children should be growing up in a family environment. But there's other reasons why it's not a congregate care is not a good thing, and the data reflects this. The highest percentage of youth on psychotropic medications are youth in group homes. The highest percentage of youth who cross over from dependency court to delinquency court are from group homes. The highest percentage of African American children being disproportionately represented in our system is in group homes. The highest percentage of youth aging out of foster care is from group homes. The lowest levels of academic achievement are of youth in group homes. And the highest risk today of being targeted for commercial exploitation is for youth who are in group homes. Now, before I left in the last year and a half ago, after a year and a half of negotiation, we actually created a protocol to enhance judicial oversight in this area. But once again, unless everyone in the system takes it seriously, these negative outcomes and these issues will persist in our system. Now, we also developed a protocol that requires timely reporting to the court every time a child's placement changes. Now, why is this important? Well, it's important because, as we all know, the movement of children is one of the banes of our existence in our system. Children need stability, and the rate that we move children is almost criminal. There can be no stability in any aspect of our life, of their lives when we move them. And so, until we do a better job of placing children appropriately, rather than just putting them someplace, and I think you know what I mean by that. Too often, and there are lots of reasons for this, but it's no excuse. Too often, the job, what we're doing is, well, can I find a bed for this child? Okay? And then we find a bed for this child and we put this child someplace. And I say put, because once again, we haven't matched that child with a placement that is designed to be successful for that specific child. And until we start doing that on a consistent basis, we're going to see this consistent moving of children, and we will never, ever, ever properly achieve the well-being of children in our system when we do that. And there are ways that can be done. Now, I see Esther giving me the high sign. I understand that. And as you might imagine, I could go on and on and on. 7 days might not be enough. But my attitude, as you see, is one of dissatisfaction with much of our system. And that includes myself, because I've been part of this system for so many years. And even though I am well aware and appreciate the fact that we do help a lot of people, and that's the beauty of it, that's what keeps us coming back to do this work day after day. But I'm not shy about telling you that I'm not satisfied here. And neither was Dr. Martin Luther King Jr. when he said many years ago, "As long as there is poverty in the world, I can never be rich, even if I have $1 billion. As long as diseases are rampant and millions of people in the world cannot expect to live more than 28 or 38 years, I can never be totally healthy, even if I just got a good checkup at the Mayo Clinic. I can never be what I ought to be until you are what you ought to be. This is the way the world is made. So the way I look at this, as long as there are more than 30,000 children in our child welfare system in Los Angeles, many of whom are not getting what they need, what they deserve, and what they are entitled to as children, that is a safe, healthy, loving, permanent home, which every child that was ever created by God is entitled to, then I'll tell you, I'm with Dr. King. So, thank you so much for listening to me today. If anybody has any questions about anything, I'm happy to answer them.
Oh, I don't see a hand.
She wants to know a little bit about the adoption day. Let me tell you, in the 1990s, ASFA was passed, and that really changed some of the dynamic of child welfare, because through ASFA, it put much more of an emphasis on permanence, and some of the legal changes said, well, we're going to create more categories where the system is not going to even allow reunification for certain families, for certain types of abuse and so forth. And we're going to shorten the time frames for reunification, specifically for younger children. And so what we saw as a result of ASFA is that and those legal changes that impacted our states as well, was that more and more children were being freed for adoption. And got to around 1997, 1998, in Los Angeles, we had a backlog of some 6,000 children for whom parental rights had been terminated. And of course, we terminate parental rights in California for the purposes of allowing children to be adopted. When we looked at the system was not responding appropriately. And really, it was a system-wide issue. So in late 1997, I got together with a couple of local entities, the Alliance for Children's Rights and Public Counsel, and we got together with DCFS and some of the attorneys in the system. He said, look, we have to figure out a way that we can somehow reduce this backlog and begin to expedite the time that it takes to complete adoptions. So what happened was that the Alliance and Public Counsel agreed to go out and recruit, organize, and train attorneys from some of the largest law firms in Los Angeles. And these attorneys were trained to take cases pro bono, wherein they would help families navigate the often complex adoption process. At the same time, the Department of Children and Family Services agreed that they would put more social workers working on adoption, provide overtime, and so forth. And the court said, what we will do is we're going to provide more courts and more time to actually do the adoption hearings. After we put this adoption project together, an attorney had an idea that maybe here's how we can do this. We can do it in kind of an assembly line fashion. We can have all the families come to our attorney's offices on a Saturday to do their paperwork, and then we'll march them right over to the court to complete the adoptions. Well, I said, no, it's a little bit more complicated than that. You can't do it that way. But there's an idea there. On one Saturday, you can bring your families together and you can work on paperwork, and then perhaps on another Saturday, we can open up the courts and do adoption hearings. And so in April of 1998, actually 17 years ago, April 15th, tax day, we opened up 5 courts one Saturday morning, and we processed 150 adoptions. 115 adoptions, and the rest was history. It was a big hit. It was a hit because we invited the media, who generally speaking don't get to go to the dependency court. Families were able to bring more friends and more families to help them celebrate. The attorneys didn't have to be in other courts on that day, and it was a huge celebration. I've often said, our dependency court, which is not typically a happy place, became the happiest place on earth on that day. And we did it time and time again. In fact, we're still doing it. And in fact, on one Saturday in 1998 or 1999, we actually completed 650 adoptions in one day. And as I said, since then, this project, which actually we have courts available every day, we've completed over 35,000 adoptions from foster care, and over 10,000 of them have actually occurred on those Saturdays. So it's something that we're very proud of, and of course, everybody around the country wanted to copy us. So now, the Saturday before Thanksgiving every year becomes National Adoption Day. And every year now, courts in all 50 states open their door to complete adoptions. And so on that one Saturday throughout the country every year, 3,000 to 4,000 children have their adoptions from foster care completed. It's pretty cool.
Hi, my name is Jay Lighton. I'm a graduate student here at USC in the MSW program. My question for you is, based on the cases that you observe, when you're on the bench, do you think it would help if there were social workers who were able to follow their clients as they move from site to site? I don't think that's currently implemented at the moment. And then my other question for you is, do you think that if social workers had more training when they are on the front lines, we only get 2 years here in the MSW program. Is that enough to deal with these complex issues, especially when they come up to your level?
Well, the first question is a good one, because one of the things that children in our system suffer from is a lack of continuity. Once again, we've heard they move around way too often. They change social workers way too often. They change attorneys way too often. And quite frankly, it used to be more so than now, they change judges more often, because when I started in the dependency court in 1990, judges were in and out. And one of the things that we worked on over the years was creating more stability within the court system. And we've had a lot more stability, and a lot of kids, I've heard this time and time again over the years, the only consistent person in their lives for many years was their judge. And so, we need to, give these kids a lot more consistency than they get, and that's certainly one way to do it. As far as your second question is concerned, the training issue is a hard issue. At the end of the day, experience is the best trainer, and I think that there's only so much you can do in the courtroom, in the classroom. There's only so much that you can do through simulation. But at least if we're going to do a lot more, if we're going to do training in the field, then social workers need to be out there with trained, experienced social workers so they can benefit from the experience of those social workers. In terms of how long it takes, really, it doesn't matter what profession we're in, whether you're a judge, a lawyer, a doctor, a dentist, or a social worker, experience is the best teacher.
Judge Nash, under DCFS cases, they're under the name of the mother. In many situations, whether in family court and dependency court, it always seems, or many times, that fathers seem to be pulled, if you will, in terms of attention that's paid to them, either within the case. And I'm curious, what has been your role, or what's possibly can the court do, where fathers, especially if they don't reside in the home, seem to be out of the picture and sometimes not taken very seriously. And even though they long to be with their children, long to connect with them, they seem to be left out. Any thoughts?
Yes, fathers have long been the forgotten folks involved in the process. And one of the things that we've concentrated more on over the years, a couple of things we've concentrated more on. Number one is really trying to get everybody in our system to at the front end of the system, make sure that they identify the parents of the child. And once again, more often than not, that means the father, okay? Because fathers can bring as much to the table as mothers. And one of the more important things that they can bring to the table, along with just their own commitment, is they have families as well. They have families for these children that can bring so much to the table, whether it's assistance to the parents who are reunifying, whether it's placements for the children, supports for the children in so many different ways. And we haven't done a good job of that, but we've gotten better at it. And of course, largely, or to a great extent, through the efforts of one of my great friends, the late Dr. Herschel Swinger of Children's Institute, he more than anybody else, really emphasized the creation of programs that are designed to help and empower fathers who are willing and able and desirous to become a positive force in the lives of their children. And he created the Fatherhood Project. And one of the things that I'm proud of is that working with Children's Institute, we are able to provide space at the Children's Court in Monterey Park for the Fatherhood Project so that the fathers can go directly from the courtroom to the office of the Fatherhood Project and begin to enroll in these programs that are designed, once again, to help them become major forces in the lives of their children. But we need more of that.